This is Rule 202.6, Requests for Judicial Intervention, RJI. A. At any time after service of process, a party may file an RJI. In an action not yet assigned to a judge except in sub B, the court shall not accept for filing a notice of motion, 1. 2. An OSC. 3. An application for an ex parte order. 4. A note of issue. 5. A notice of medical, dental, or podiatric malpractice. 6. A statement of net worth. Or 7. A request for preliminary conference, unless such notice or application is accompanied by an RJI. Where an application for person relief is made, payment of the fee shall only be required upon denial of application. A request for an RJI must be submitted in duplicate on a form authorized by the fucking chief administrator with proof of service on other parties to the action, but proof of service is obviously not required when the application is ex parte. B. An RJI shall be filed without fee for any proceeding to a court, and there is a list of 11 of these. So this is the RJI without the fee. 1. Not signed to an action or proceeding. 2. Petition for name change. 3. Petition for sale of church or nonprofit property. 4. Habeas corpus proceeding where movement is institutionalized. 5. Application for out-of-state disclosure assistance. 6. Mental hygiene law 9, Article 9. 7. Mental hygiene law, Article 10. 8. Appeal to a county court from a court of limited jurisdiction. So that would be like a town or village court. 9. Application to vacate a judgment on grounds of bankruptcy. 10. Application for emergency surgery. And 11 is only within New York City. Uncontested annulment, divorce, or separation. Not an uncontested matrimonial according to this, because that only includes 3 possible matrimonial actions, and not all of them are listed here. So it should just be memorized as within New York City, an uncontested annulment, divorce, or separation. 202.7, calendaring of motions, uniform notice of motion form, affirmation in good faith. A. There shall be compliance with the CPLR for bringing in motions. In addition, except as provided in sub B, no motion shall be filed unless there is served a notice of motion, and with respect to a motion relating to disclosure or a bill of particulars, so basically a discovery motion, has to come with an affirmation that counsel has conferred with counsel for the opposing side in a good faith effort to resolve the issues raised by the motion. Here you have the notice of motion, and there's the name of assigned judge, title of the action, venue, county, where the court it is, index number, checkbox if oral argument is requested, and then there's this whole thing, attorney or firm for the moving party signature, and then you have to put in the person that you're serving the motion with, the other parties. C. I think that's C. The affirmation of good faith effort to resolve the issue raised by the motion shall indicate the time, place, and nature of the consultation and the issues discussed, and any resolutions, or shall indicate good cause why no such conferral was held. D. An OSC or ex parte relief need not contain notice of motion, but shall contain affirmation of good faith if such affirmation is otherwise required by this section. E. Ex parte motion submitted to a judge outside of the county where the underlying action is venued or will be venued shall be referred to the appropriate court in the county of venue unless judge determines that the urgency of the motion requires immediate determination. F. Any application for temporary injunctive relief, including but not limited to a motion for a stay or a temporary restraining order, shall contain, in addition to other information required by the section, an affirmation demonstrating there will be significant prejudice to the party seeking the restraining order by giving of notice. In the absence of a showing of significant prejudice, the affirmation must demonstrate that a good faith effort has been made to notify the other party of the time, date, and place, so date, time, place, that the application will be made in a manner sufficient to permit the party an opportunity to appear to the in response to the application, and that pretty much has been interpreted as 24 hours notice. This subdivision shall not apply to OSCs or motions in special proceedings brought under RAPL, nor to orders to show cause requesting an order of protection under Article 2, Section 240 of the DRL, unless otherwise ordered by the court. And then they're noting here, if any party is appearing pro se, the name, address, and telephone number party shall be stated. And that's because on that form here, there's only spaces for the attorneys to write, as you can see. Point 9, special proceedings. Special proceedings shall be commenced and heard in the same manner as motions that have not been assigned to a judge as set forth in 202.8, except that they shall be governed by the time requirements of the CPLR relating to special proceedings. At conferences, any party may request to appear at a conference by telephone or other electronic means. Where feasible and appropriate, court is encouraged to grant such requests. Okay, Rule 202.11 says reserved. 202.12. Now this is different than Rule 202.12-A, which is specifically talking about residential foreclosure actions. This is preliminary conference. A, any party may request a PC at any time after service of process. Request shall state title of action, index number, names, addresses, and telephone numbers of all lawyers appearing in the action and the nature of the action. If the action has not yet been assigned to a judge, the party has to file the RJI together with the request for PC. The request shall be served on all the other parties and filed with the clerk for transmission to the assigned judge. The court shall order the PC in any action upon compliance with the requirements of the subdivision. Court shall notify the parties of the scheduled conference date, which shall not be more than 45 days from the date of request for judicial intervention is filed, unless the court orders otherwise, so that is a pointless time rule, and a form of a stipulation and order prescribed by the fucking chief administrator shall be made available, which the parties may sign, agreeing to a timetable for discovery within 12 months for a regular standard case, 15 months for a complex case. If they sign the form or return it to the court before the PC date, such form shall be so ordered by the court, and unless the court orders otherwise, the PC shall be canceled. If it's not returned by all parties, and the parties have to show up at the conference. Except where a party appears in the action pro se, a lawyer thoroughly familiar with the action and authorized to act on behalf of the party shall appear at the conference. Okay, so here's the more modern stuff coming in. Where a case is reasonably likely to include electronic discovery, counsel shall, prior to the PC, confer with the other counsel with regard to anticipated electronic discovery issues. Further, counsel for all parties who appear at the PC must be sufficiently versed in all matters relating to their clients' technological systems to discuss competently all issues relating to electronic discovery. Counsel may bring in a client representative or an outside expert to assist in such e-discovery discussions. 1. A non-exhaustive list of considerations for determining whether a case is reasonably likely to include electronic discovery is I. Does potentially relevant electronically stored information, and then in parentheses it's got like little quotes and it says ESI, exist? Double I. Do any of the parties intend to seek or rely upon ESI? Triple I. Are there less costly or less burdensome alternatives to secure the necessary information without resorting to discovery of ESI? IV. Are the cost and burden of preserving and producing ESI proportionate to the amount in controversy? And V. What is the likelihood that discovery of ESI will aid in the resolution of the dispute? C. The matters to be considered at the PC shall include 1. Simplification and limitation of factual and legal issues where appropriate. 2. Timetable for disclosure. 3. Where the court deems appropriate, it may establish the method and scope of any electronic discovery. In establishing the method and scope of electronic discovery, court may consider the following non-exhaustive list, including but not limited to I. Identification of potentially relevant types or categories of ESI and the relevant time frame. Double I. Disclosure of the applications, a manner in which the ESI is maintained. Triple I. Identification of potentially relevant sources of ESI and whether the ESI is reasonably accessible. IV, implementation of a preservation plan for potentially relevant ESI. V, identification of the individuals responsible for preservation of ESI. VI, the scope, extent, order, and form of production. VII, identification, redaction, labeling, and logging of privileged or confidential ESI. VIII, clawback, whatever that means. It says claw-back. Okay. Or other provisions for privileged or protected ESI. IX, the scope or method for searching and reviewing ESI. And X, so 10. The anticipated cost and burden of data recovery and proposed initial allocation of such costs. All of that was part of 3. 3 was the scope and method of electronic discovery, and then that was a huge list. All right. 4, addition of other necessary parties. 5, settlement. 6, removal to lower court pursuant to 325. 7, any other matters court may deem relevant. D, at the conclusion of the conference, court shall make a written order. Okay, so let me go back to that list. 7, any other matter court deems relevant. D, at conclusion of conference, court makes a written order with directions and the stipulations of counsel. In the alternative, in court's discretion, all directions and stips of counsel may be recorded by a reporter. Where the latter procedure is followed, the parties shall get the transcript and equally share the cost, unless the court in its discretion says otherwise. Transcript shall have the force and effects of an order of the court, shall be filed by the plaintiff with the clerk of the court. So the transcript shall be filed by the plaintiff with the clerk of the court. E, the granting or continuation of a special preference shall be conditional upon full compliance by the party who has requested such preference with the foregoing order or transcript. When a note of issue or certificate of readiness are filed pursuant to 202.21 in an action to which this section is applicable, the filing party, in addition to complying with all the rules, shall file the note of issue and certificate of readiness, an affirmation or affidavit with proof of service on all parties who have appeared, showing specific compliance with the PC order or transcript. In the discretion of the court, failure to comply or the making of unnecessary or frivolous motions by a party shall result in imposition of costs or sanctions. G, a party may move to advance the date of a PC upon showing in special circumstances. H, motions in actions to which this section is applicable made after the PC has been scheduled are denied unless there is good cause shown why such relief is warranted before the PC is held. Damn. Okay, let me just make sure I understood that. And this applies to all actions. H, it says motions in actions to which this section applies made after the PC has been scheduled. So if you make a motion after the PC is scheduled, the court can just deny it. I mean, this doesn't, I don't know if this probably doesn't apply to matrimonials. Oh, except it does, as I'll get to. I, no action or proceeding to which a section shall be deemed ready for trial unless there's compliance. J, the court can order other conferences, necessary or helpful. K, the provisions of this section shall apply to 1, matrimonial actions and actions based upon a separation agreement. So that's 2. Med mals. 3, real property tax assessment reviews within New York City. That's 4. It says they shall apply to matrimonials, actions on a separation, med mals, and real property tax assessment. And it only says med mals. It does not say the other two. Podiatric, whatever. It doesn't say those two. J, the provisions of this section shall apply where a request is filed for a PC in an action involving a terminally ill party governed by CPLR 3407 only to the extent that the provisions of the section are not inconsistent with the provisions of 3407. In an action governed by 3407, the request for PC may be filed at any time after commencement of the action and shall be accompanied by the physician's affidavit required by that provision.